Hi, everybody. Thanks for waiting. Today's special guest is attorney Cyril Yu, who is a senior prosecutor from California. Cyril, thanks for being here.
Thanks for having me again.
Sure. Would you like to give a very brief introduction about yourself?
Like Judy said, I'm a prosecutor in California. I've been a prosecutor for 22 years. And that's pretty much it in terms of what you said.
Okay. But you're from California, and you went to
from California. Yeah. Yep. Born and raised, lived all over the state. Yep.
Great. Okay. And what kind of cases do you handle now?
Currently, I'm working on post-conviction cases, and so most of my focus is on murder cases and attempted murder cases that have been already previously litigated, whether it's through trial or through a plea. And there's post-conviction type of work that's being done, largely a result of things that our legislature has passed that requires us to re-examine certain cases for very particular reasons. Basically to see if under current law we'd be able to prove them, and if not, then the defendant would be entitled to a resentencing.
I see. Okay. Well, how much delving into this Adelson Markel case have you done?
I have not. I mean, I really have not looked at it in quite a few months. I think the last time I was on was probably the last time I looked at it. So it's been a while.
Okay, great. Well, people are so happy to hear from you. So we'll just go ahead and bring this up. This is done with permission from Deep Dive True Crime. And we're just going to take it maybe in 5-minute chunks to watch Catwoman's closing argument and give commentary. Okay?
Sounds good.
Thank you. Thanks.
My burden to prove this case to you beyond a reasonable doubt through evidence. And generally speaking, the defense's job is to poke holes in the evidence and argue that it falls short of meeting that high burden. And we also learned at jury selection that the defense does not have to prove anything. But sometimes if the law enforcement investigation is so thorough and so compelling that there's really no way to poke holes in the evidence, he has to basically admit his own words, his own text messages. That stuff is undeniable, right? And those things prove that he was in cahoots with Catherine McDaniel in 2013, arrest in October of 2016. He knows he can't deny that he paid the killers because of this bizarre practice he had of stapling his money. So sometimes when a defendant can't attack the facts or the law, they instead try to explain it away by saying, you can't trust what you're seeing. It's not what it appears to be. It's actually something else entirely. Often, as in this case, the individual explanation, so when you zoom in on one piece of evidence with its attached explanation, can be like, maybe. But when you zoom out and you add all these things together, this explanation, and this explanation, and this explanation, this coincidence, and this coincidence, and this coincidence, it starts making less and less sense. It starts being less and less reasonable. And when you zoom out from the defense's theory, it's really unreasonable, right? Because to find it reasonable, you have to buy a lot of things that he's selling. The most obvious of which is that because Fredo Garcia hated him, he and Rivera traveled to Tallahassee twice to kill someone he hated in hopes that he would give them money for it on the back end. Please think about that. To hit this defendant where it hurts, these two dudes with no connection at all to Dan Markel and without 2 nickels to rub together, rented a car and paid for gas to come to Tallahassee and stay in a hotel twice in order to kill someone that this defendant hated, to harm him. And for what? To maybe get money. Maybe he just turns him in for murder. Why not just kill and rob him if what you're after is money and there's no hired hit? Why not just kill and rob him if your motive is, we hate him? Then the bad guys don't even have any contact with him, according to his own story. They didn't threaten him. They did not beat him into submission. Instead, they sent his own girlfriend to extort him on their behalf. And without any actual contact from the bad guys, the defendant just opened up his safe and handed over his beloved money that he had saved his entire life since he was a child. He just handed it over. Take it all. And when that amount wasn't sufficient, these stone-cold murdering gangsters let the defendant go on a payment plan to give him the rest of the money. They let Catherine Magbanua skim off the top each month. And never, over the next 2 years that he was being extorted monthly, these gangsters, remember that money doesn't go to the principal. That's $1,000 a month. They never showed the remaining $195,000 that this defendant has agreed to pay them. Then you also need to find reasonable that over the 2 years of this supposed extortion layaway plan, that the defendant continued to do what? Send these kissy faces and love texts to Catherine Magbanua. He's sending these messages to a woman who got him into this mess, and he says he didn't suspect she was involved. What? What do we know about this man? He didn't suspect she was involved. She's taking the money. He's never even heard from the bad guys. He didn't see it that way, that she got him into this mess. They grew closer after she began extorting him for $3,000 a month. Meanwhile, the defendant and Catherine Magbanua break up. She continues to maintain her direct and indirect contact with Sigfredo Garcia, the man who's extorting him, the man who murdered his former brother-in-law in cold blood. But he sees her as a friend. The kissy faces and the I love yous continue. Even after Catherine Magbanua got back together with the man who executed Dan Markel, the father of his young nephews, and a guy who's actively extorting him, this defendant continued to reach out to her over and over again to offer her favors and gifts, including a birthday gift for Garcia, and to tell her he loves her and how lucky he is to have her in his life. Lucky? Next, to find a reasonable doubt here, you have to find it reasonable that the defendant never texted or talked about this first layer of extortion. Why? According to him, because Catherine Magbanua said, let's never talk about this. So they didn't. Then you have to believe he never reported or revealed this information to law enforcement out of fear of the gangsters. And finally, you have to believe that this living in fear of death by gang members over 2 years didn't cause a change in his general demeanor that his friends noticed, but later the bump from law enforcement did. He says that's because, well, I became worried that I might be falsely arrested. So I wasn't a hot mess when I was being extorted by gang members and threatened to be killed and my whole family killed. But I became a hot mess when I started to get worried that the cops might be getting closer. And I have no real way of knowing if all this stuff sounds ridiculous to you, if it sounds reasonable to you, or if y'all just heard so much stuff that you're totally confused and can't even remember what the evidence in the case.
Okay, so let's stop here. It's been about 5 minutes.
Okay.
What are your impressions, Cyril?
It's a good way of arguing this. I mean, obviously, what's happened during the course of the trial, and I did not watch the trial, so I'm just kind of surmising this from her argument as well as what I've known from the prior trials. And so what's been presented by the defense is a reasonable alternative story. And so what do you do with that reasonable alternative, right? You go through it and basically say, the story doesn't make a lot of sense. This is, in cases from a defense standpoint, you've got a couple different, approaches to it. And one of the approaches that the defense will oftentimes take is present an alternative version of the facts, right? One that points towards innocence. And what she's doing is methodically dissecting that and saying, this story that they're concocting, when you look at the details, is ridiculous, right? She actually started off by talking about, hey, if you take a magnifying glass and you look at, the prosecutor's case, yeah, you can poke holes or you can attack, particular pieces of evidence. But when you look at the overall story, it makes sense. And what she's basically saying is you can take a magnifying glass to the defense's case, and what you will see, both in the details, that it doesn't make any sense, and on the broader story, it doesn't make any sense either. And so it doesn't support an argument for reasonable doubt because there isn't a reasonable alternative. And so she's done a very good job of kind of, summarizing where their story falls apart and really drawing that contrast between what would be conduct you would expect given these facts and what in fact is his conduct, right? It's wholly inconsistent with how you'd expect someone to behave in these circumstances. And so the story doesn't make any sense when you look at everything in that context. So I am kind of curious where she's going next. You did pause it in the right place. She seems to be transitioning into a different argument at this point.
Okay, thank you. Okay, we'll go on.
But they only need to get one of you confused enough to derail this whole thing, right? So I've got to go through each thing with you. Your verdict has to be unanimous. So I want to go through the testimony, I want to review the evidence, and I want to spend a little bit more time talking about this multitude of explanations the defense has offered in an effort to really turn each piece of evidence on its head. This is Dan Markel. He is the victim in this case. A brilliant lawyer, a funny guy, a son, a colleague, a brother, a mentor, and a friend. But most of all, a father. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his access to those two little boys in the wake of a bitter divorce from their mother. And despite the defense's efforts to characterize their client as the real victim here, Dan Markel remains the only victim in this case. The only thing he was guilty of is fighting like hell for those kids. And he lost. He didn't lose in court, but he lost. This is what he looked like before this defendant hired a hitman to kill him. And this is what he looked like afterwards. The evidence has shown that on July 18, 2014, this brilliant man was gunned down in broad daylight in the driveway of his own home. His horrific death ultimately set police down two separate paths following the two most promising leads they had. The first was to chase down that Prius that Mr. Geiger saw fleeing the crime scene. And we'll examine those efforts in detail. The second path was to ask, as we would in any murder investigation, who might want to have done this? Who would want Dan Markel dead. And within 1 hour of the shooting, before Professor Markel was even pronounced dead, this path was already pointing to the defendant. When his sister revealed to law enforcement that her family hated Dan Markel and that her brother, Charlie, had joked about hiring a hitman to kill him. And this trash talk, of course, would be meaningless had he not been killed by a hitman. So who did it appear had a motive to want Dan Markel dead? His own family. And what offense had Mr. Markel committed against these people? Refusing to let his children be taken away from him? Objecting to them disparaging him to his kids? The evidence has shown that the Adelson family was all about psychological warfare. And when all else failed, they were willing to go even further to win. I want to examine this motive in more detail and look at exactly how it's attributable to this defendant. Despite the defense efforts to minimize this, it's really clear that the divorce between Wendy and Danny was a particularly nasty one. They fought over everything, all the way from the children down to the bicycle and the tennis racket. In January of 2013, Wendy Adelson filed a motion to allow her to relocate to South Florida with the kids. They were 2 and 3 at that time. As one basis for this request, Wendy cites the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents. Wendy Adelson also alleges in this filing that the husband has also created a hostile work environment for the wife at FSU School of Law. Wendy Adelson viewed herself as stuck in Tallahassee, a characterization which she now denies, but one which was used to describe her situation by Jeffrey Lacasse on the witness stand and also in her own pleadings in these divorce filings. In Markel's answer on page 80, he seeks continued equal time sharing in Tallahassee. He seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of the kids. Then we go to this May email from Donna Adelson to Wendy. These emails are offered as examples of how invested Donna Adelson was in this litigation and in Wendy's life in general. They reveal that relocation was a huge priority for Donna and that it was also a high priority for Wendy, Harvey, and the defendant as well. Wendy testified that her mom really wasn't that involved in her divorce proceedings. Again, these emails prove the opposite was true. On May 3rd, 2013, this email references Dan's divorce filing as, quote, his 23-page rant. She then crystallizes the importance of relocation, stating, the most important part of your divorce is relocation, in bold. I since not met her burden of proof that a relocation is in the best interest of the minor children. Like the heroine in her book, Wendy and the boys were officially stuck in this small stop on the way to what we had previously known as civilization. Wendy worked hard to try to convince you that none of this was a very big deal to her, her mother, or her brother. And she said she was expecting to win everything in the divorce. She was expecting Danny to lose everything in the divorce. She was partly right. Danny did end up losing everything, but not in court. She had already lost relocation, and her attorney had to get off the case as a result of whatever Danny was filing in court. And he was poised to really take her through the ringer with this grandma motion, the fraud allegation, and the contempt motion that was all pending. Even if he wasn't going to be successful, folks, it was going to be a very unpleasant ride for Wendy Adelson. But as we have learned, Jibbers hadn't beaten the Adelson family yet. On the stand, Wendy Adelson suggested that relocation was not a big issue for her. It was just suggested by a friend, but the other evidence in the case suggests the opposite. Jeffrey Lacasse said she was a complete mess over the litigation, especially the relocation. She wrote a book about a human rights attorney who was stuck in a small town in the Florida Panhandle because of her hapless Canadian professor husband's job at NFSU. And maybe most importantly, Wendy filed this motion for relocation. Her lawyer didn't file it without her knowing. Was the motion doomed from the start? Wendy clearly hoped not. But there were other ways to skin the cat. Here's a June email from Donna to Wendy. In response to the court order denying relocation, Donna emails Wendy, quote, "It's time for action. It's time to take control of your life and not let Jibbers think he's won anything by having you remain in Tallahassee, 8 hours away from the only family you have. Let's show this F blank, 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 what will make him absolutely miserable. And later, the rest of your life, and consequently, Dad's, mine, and yes, even Charlie's, will be affected by how well you can perform/act before July 31st. You can be a good actress when you want to. I've seen you in action. You need to put on the performance of your life. Jibbers hasn't beaten the Adelson family yet." Then on June 25th, this is continued, that same email, we get a plan of action. Take a photo of the boys dressed nicely, standing at the front door by the sign of a Tallahassee church. They're Jewish, remember? Then change your Facebook status to this one so everyone will see this. Perhaps a line under the photo with "New beginnings in Tallahassee" might be nice. How happy do you think he will be? Make arrangements to get the boys caught up with a private tutor at the Teenage Catholic Church who will come to the house to teach the young men about Jesus. If you don't have time to arrange this, I'll be happy to do it for you. Let Jibbers know that your children will be baptized in the Catholic Church, and you'll certainly invite him to the event. I've already checked this out, and the baptism can be arranged within 2 weeks. We can send out evites to Jibbers, his parents, sister, and anyone else you want to invite. 4, I'm looking into summer camp programs for the boys. We will pay for it, even if the boys end up only going for the few days that they're in Tallahassee with you. 5, register them for toddler classes at the church. I've looked into this too. Even if they don't actually go, we can show Jibbers that they are enrolled for the fall semester.
All right, let's take a break here. Any thoughts here, Cyril?
What she started off with in terms of where it picked up was she talked about wanting to go through the evidence. So one of the things that prosecutors kind of have to make a decision on is how much time do I want to spend going back through all the evidence in a particular trial. The longer the trial, the more you might do that just to refresh the jurors on what it is that was presented. And what you're trying to do is you're really highlighting those aspects of the case that are most important, and you're focusing on the issues that matter the most in your particular case. So she spent a little bit of time on the actual murder itself. She talked about Dan and why this is important to remember that he's the victim, but she really didn't spend a lot of time talking about the murder in itself. And she may get to it later, but it's something that she doesn't need to dwell on because no one's disputing the fact that Dan Markel got killed. I don't think there's much dispute as to who did the killing, even from the defense's perspective. Really what it comes down to is who has the motive to do so. And she started that off basically by saying, hey, look, we have 2 different branches of this investigation in very logical fashion, right? You want to be able to provide the jury a very logical explanation as to how the pieces of the case come together. And she did that. But the other thing that you want to do is you want to really lean into what the theory of the case is. And so when she put up that graphic that has, Charlie right in the middle and kind of connecting the pieces. Okay, so here's Charlie. he's the linchpin that connects the killers to Dan, right? Through Wendy, through mom and dad, into that. And so you're really kind of emphasizing he's the critical link here that connects all these pieces together. And I'm really driving home the point of the theory here is this is the motive as to why this murder happened, right? Really pushing against the narrative that the defense is presenting by laying this out very, very clearly. And what I do enjoy, or what I do like of how she's gone about it, is one of the things that I always look for in my cases is what are the pieces of evidence that cannot be refuted, right? When you talk about witnesses, witnesses can obviously be very biased in how they sway their story. And she kind of mentioned that in terms of Wendy, right? When she's on the stand and she's talking about, oh, well, this really didn't mean a whole lot to me. Well, what do you look at that impeaches that, right? That attacks that narrative? Well, you look for pieces of evidence that are indisputable, right? So you look at an email, for example, that's written from her mom to her, or from her to her mom. Those are things that cannot be disputed because they're literally in writing, right? You can try to explain away certain things, but when it's written very, very clearly, those are those immovable pieces that you cannot avoid. And if the defense's story doesn't align and handle all of those fixed pieces, it makes it a lot harder for them to be able to convey their story. And so she's doing a good job of just weaving in those critical pieces of evidence. And like I said, you're not going to go through everything, but what you're going to do is you're going to hammer at those points that help drive the theory of your case. And she's been doing that.
Yeah, I also think focusing on these emails again brings to light how involved the whole family was.
Right.
That this divorce affected the whole family, including Charlie. So
correct. Yeah, because basically what you're trying to establish is there's a conspiracy among these members of the family that they had a motive to want Dan dead when things did not work out. But you can tell there's a complete coordination between various members of the family. One of the things that I think she also does a very good job of saying, hey, Wendy not only is saying, hey, look, these things aren't that important to me, and she's basically saying Wendy is manipulating or lying. When you bring out an email that says, oh, hey, you're a really good actress, right? From her mom of all people, not somebody else who's blowing smoke or whatever, but someone who's basically saying you're capable, you're able to do these things. You should do this because we need to get this done, right? So it very much conveys that notion that Wendy is heavily involved in this, and her credibility on the witness stand is something that the jurors can pay attention to based on even mom's comments.
Mm-hmm. Yeah, we'll take most of the question towards the end, but I did want to point out this question. How did the divorce affect Charlie? Well, there are emails where Donna was griping to Wendy about how the whole family's income had gone down because of this whole divorce and custody mess, because Donna was the office manager and they all worked together at the dental practice. So the family income was negatively impacted because Donna had to keep going to Tallahassee to help, and Harvey too. So, okay, but thanks for that comment. Okay, shall we go on?
Sure, go ahead.
Okay.
And you cannot tell anyone this is an act. Take control from him. Get to him psychologically. He's going to want you to stop this. You have one final opportunity to make him angry. We want him ticked off so he realizes that he could lose control over his kids. We plan to make a financial offer to him to allow this relocation. You need to work this plan, and we'll help you through it so that it may affect how much we offer him. Maybe he's willing to let you relocate if he knew his children could attend this private Hebrew academy. Or perhaps he'd like them to invite him to a Christmas party at their other Sunday school. Let's get this going now. I know you would never want to think that you didn't do absolutely everything you could to come down to your family. Dad and I have changed our lives this year to support you and assist you and the boys in every possible way. Charlie has accepted the loss in the office business income for us to do this because he loves you and wants only the best possible future for you. It's time for you to show us that you can put on the performance of your life for the next few weeks. And then on June 27th, she follows up with another email along the same lines, criticizing the judge and Wendy's attorney and adding, obviously the court isn't out to help you. It's clear since Judge Hobbs' last ruling that she could care less about anything you have to say on your behalf. You need to help yourself. You know, Wendy, most of the wars that have been fought for the last couple of thousand years have been fought over religion. These emails are such telling glimpses into the family dynamics behind this murder. This email is just an example of how relentless Donna Adelson was. And it's clear from these emails that she's conferring with the defendant on these plans that she's proposing. Charlie brought up a good point when he said that Americans were dropped behind enemy lines during World War II wearing Nazi uniforms to get what they wanted. They had a job to get done, and they did what they needed to accomplish it. You have a job to get done in a very short time frame to accomplish it. If you dressed the kids up in Hitler Youth uniforms and brought them down here, I could care less if it was an act of defiance that would show jurors that he's not in control. Why not stand up to this fucker? Why not fight? That's all this is, Wendy, an act of defiance that will put a scare into this jackass. It will infuriate him. You need to see the big picture. You need to look into the future of what a life without your only family nearby teaching in Tallahassee with Danny always in the picture will give you. It's not a pretty picture. Not everything one has to do in life is comfortable or easy. The extremism that Givers is already teaching the boys is nothing more than brainwashing. Religion is brainwashing, control of the masses. I don't think you realize the type of offer we're considering. We're planning on you, Charlie, Dad, and I going as high as equal parts in a $1 million offer. That's $333,000 from each of us. We're a team. We can't do this without your help. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family teaching in Tallahassee. Even though the divorce was final on July 31st, 2013, the anger and bitterness associated with this split was still festering. Litigation continued and even increased as both parties filed motions over the next several months alleging that the other was violating the marital settlement agreement, and both parties seeking to have the other side held in contempt of court. In October of 2013, Wendy filed a motion to enforce the marital settlement agreement and have Dan held in contempt. Dan was hearing, and the defendant was hearing about all of this as it went on from his mother, as indicated in the emails and in the text messages shown here as well. Here she's telling him how terrible things are for Wendy and how it's negatively affecting his dad's health. Then later that month, when Wendy was about to make the second dumbest mistake of her life after marrying Dan Markel by buying a house in Tallahassee, Charlie says Wendy probably hasn't mentioned it to him because it's stupid. And then after he gets Wendy to pull the plug on the house, he's praised as the miracle worker that solved this problem. This text was sent on Halloween of 2013, the very day that Catherine McDaniel testified. This defendant broached the subject to her of, hey, do you know anybody that could rough somebody up? The defendant was hearing about Wendy's situation regularly from Donna. Here we see Donna telling the defendant how angry at Wendy's attorney and stressed out Wendy is. That's on February 15th of 2014. And here's another text from Donna Adelson to Charlie Adelson 4 days later, discussing the details of Danny's actions and expressing how much she hates him. Here on March 4th, 2014, we have Donna planning to speak in private with the defendant while she's at the rest stop in Gainesville. She asks him to delete this message after he reads it. Although he's not with Harvey, and Harvey nor his birthday are mentioned in this text message. All that's mentioned in this text message is, I'm going to pull over at a rest stop and talk to you in private. This is the grandma motion. On March 26, 2014, less than 4 months prior to this murder, the defendant files his grandma motion, the counter motion for enforcement of marital settlement agreement on parenting issues, and motion for contempt and sanctions. Again, alleging that Wendy is not facilitating communication between he and the kids and getting after Donna personally. In this filing, Dan Markel alleges that on 3 separate occasions in November of 2013, the children informed him of their maternal grandmother, Donna Adelson, disparaging him. The boys indicate that, quote, "Grandma says you're stupid. She says you are trying to take her sunshines away from her." And, quote, "Grandma says she hates you." Dan Markel requests the court, quote, "enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, and to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father." Contrary to what Wendy Adelson told us, we learned this issue was taken seriously by both sides, and that Dan Markel was particularly hot at the time of his death because of some recent issues that were going on. So to the extent that there was any banana bread peace offering made, it apparently fell short of diffusing the issues within this family. This situation was a pressure cooker, and it was about to blow.
Okay, let's take a break here. Cyril, we actually have a evidentiary question that
Okay.
I'm hoping you can answer. Somebody asked, could those emails be introduced as evidence without Wendy's testimony? So how do you, let's say you just have a bunch of printouts of emails. Does one of the recipients or the sender have to be there to testify?
Not necessarily. Yeah, not necessarily. It is one of the easier ways to get in text messages and emails because it does help provide context from the witness as to what was happening, why was this being sent. But no, you don't actually need. You wouldn't necessarily need Donna Adelson. You wouldn't necessarily need Wendy for those things to be admissible. And so how you'd go about doing it is you would tell the judge, and these are all decisions that are being made by the court, and the court would have to decide. And I don't know how it is under Florida law. There may be very specific things. In California law, the statements of co-conspirators are admissible, right? So any statements that are made during the course of a conspiracy by co-conspirators is admissible, right? So at this point, is there a conspiracy? Does it evolve into a conspiracy that involves murder? And so these are statements by co-conspirators that kind of lend credence to the existence of a conspiracy. And in those instances, what you're simply trying to do is foundationally, what do I need to do to establish these messages are by who these individuals are? So a lot of, depending on the timing of it, the companies, the phone companies and whatnot that are your providers will oftentimes keep copies of the cell phone records. So there's obviously a lot of different ways that those things are stored. And what you would do as a prosecutor's office or if you're law enforcement is you would subpoena, get a court order for those particular records. And then what you would need to do in those instances is establish that particular phone number belongs to this particular individual, right? So figure out what Wendy Adelson's phone number is, you can figure out what Donna's phone number is, and then when you can prove that, and you can use obviously corporate records, business records to prove that, then you can connect those records to those communications between these parties, right? So typically in these things, you will see just phone numbers, but once you establish what the phone number is, then you can readily identify who the people are that are having these conversations. So that'd be one way of doing it without necessarily having to call either Donna or Charlie or Wendy. And you don't really need all of the parties. You just need one that can essentially attest to either side of the conversation if you're to do it that way. But like I said, you can actually do it without having any of the parties being called as a witness to do it if you can go through the provider and obtain that information. And oftentimes you'll have statements from the individuals that are being interviewed, right? A law enforcement officer will oftentimes, when they're interviewing a witness, get down all of their personal information. What's your name, date of birth, what's your phone numbers, what's your address, what are ways that we can contact you? And so if somebody says, this is my phone number, well, now you're going back to the phone records and saying, well, the phone company actually provided me with this subscriber information, which says, oh, this is Wendy Adelson at this address, whatever. So there's a lot of different ways of being able to prove that a phone number belongs to a particular person. So hopefully that kind of answers the question.
Oh, okay. So who would testify about it, though? Would it be the investigator or some sort of forensics expert?
You wouldn't necessarily need a forensics expert to do it. Oftentimes you can just use an investigator, because the investigator is oftentimes the one that is contacting is trying to figure out, who's the provider, AT&T, T-Mobile, whatever. And then you're providing, you're doing a search warrant or whatever for those particular records. You would oftentimes call the records custodian to testify. Sometimes, again, depending on your state, or even the stipulation by the parties, because there's a recognition of let's not waste our time calling in somebody to basically say, hi, I work for T-Mobile. Yes, I've reviewed these records. These are records that our corporation maintains. This is information that no one's really going to dispute, right? And so for the most part, oftentimes you'll see parties that will just we'll stipulate foundationally that these records are obtained, from T-Mobile, and this is the subscriber information, that type of stuff. And then what you'd have is your investigator testifying, I reviewed these records, in response to a search warrant that I served. These are the records. I went through the records and I identified which were the phone records for Wendy Adelson, Donna, Charlie, and then you would do the presentation and kind of talk your way through, what statements are being made by who, what are the timeframes that this is happening. And so, that's the easy way of, pretty straightforward way of doing it. Even as a prosecutor, you could do that yourself, depending on how you choose to introduce it. And lastly, you could do it in this manner, which is that you've introduced the phone records, but you're not going, and you've established through your witness what phone number belongs to who, but you're just saving it for closing argument. Or you can use it in opening, and then you're using it in closing, because once that evidence is in, you can use that however you want. And if she hadn't talked about it all during the course of the testimony of the investigator, that's fine. She can still use it at this stage because she's laid the foundation for all these phone records. She's established which text message belongs to who, and she can basically tell the story in the manner that she is because all the evidence is already in evidence.
Okay, thank you. Yeah. Any comments on what Georgia Kappelman just said in the last 6 minutes or so?
She's continuing on of kind of building that case in terms of, covering what it is in the divorce proceedings that would lead this family to go to this extreme, right? Because people are familiar with, just from your own personal experience, jurors, and I don't obviously know anything about the panel if that's there, but as a prosecutor, what you're doing is you're tapping into the life experience of the jurors that are there. And so they've probably, a bunch of them have probably, either known friends or families or themselves that have gone through difficult divorces, and so this is not an uncommon experience for your average juror. But the question is, the average situation, even with a contentious divorce, doesn't lead to murder. So what is it that tipped this over the edge? And so she's kind of driving that in that direction of building upon what you know about these proceedings and the personalities of the individuals involved, and what is that motivation that kind of gets you there. So she's kind of building in that direction.
Mm-hmm. Great. Okay, so let's go on. This is sort of sped up.
Yes, I noticed that. I appreciate that.
Grandma motion was never decided by the court because Dan Markel was murdered before it could be heard. Whether or not that is a coincidence in timing is up to you all to decide. Wendy told you that she and Dan were getting along pretty well at the time, the weeks leading up to his murder. But this assertion does not fit with the rest of the evidence in this case. In fact, her own court filings are completely contrary to that assertion. In addition, her boyfriend at the time, Jeffrey Lacasse, told you all that she took all of this very seriously, that she became upset every time there was a filing, and that her behavior became increasingly emotional and erratic as the time led closer and closer up to what ultimately was the murder day. According to Lacasse, she was especially concerned about the relocation issue. And Stephen Webster, he was Professor Markel's attorney, testified, told us that Markel was irate at the time of his death over two issues. The first being Wendy enrolling one of the kids in a school without consulting him, and the second one being him overhearing Donna Adelson refer to him as stupid on a recent Skype visit that he had with the boys. So this was far from the peaceful situation that Wendy was trying to sell you. Why was she trying to sell you that? Was she trying to protect her brother? She even told law enforcement at her interview on the day of the murder that she wanted everyone held accountable for this to the fullest extent of the law, unless it was her family. The defense seems to be telling you the litigation between Danny and Wendy was not a very big deal because minimizing the litigation minimizes the motive for the Adelson family to want Dan Markel dead. They even called Wendy's attorney to tell you that relocation was a lost cause. But what she actually said was, yes, I lose most of these motions, but in this case, I actually thought there was a chance because of some of the surrounding circumstances. And I thought, well, maybe they called her to say the divorce was routine, but what she actually said was this case was odd. That was her word, mainly because Dan Markel came after her personally, forcing her to withdraw from the case, which had never happened before. So what her testimony proved was that this was not a routine run-of-the-mill divorce proceeding. It was one of her more difficult cases. And she didn't even have Donna in her ear like the defendant did. So the motive was clearly there. The question then becomes, was the defendant successful in distancing himself from that motive in your eyes as jurors? He says that the litigation had no impact on his life. The emails suggest otherwise. He's included on these texts. He's all over the wiretap, meddling in Wendy's life with Donna. Could the defendant have cared enough about his sister's marital problems to commit murder? Maybe, maybe not. But if he didn't, his mom certainly cared enough for both of them. And she was in his ear all the time. In defendant's own words, you can't have a miserable mom. To illustrate this point, I refer you back to the emails and to that phone call that I played that happened before the bump, where Donna and the defendant are discussing this boyfriend of Wendy's at that time, Dave. This call, along with the call about Wendy taking a particular job, which is also on that same exhibit, I think it states 130, was offered as examples to show you how the dynamics work in this family. Wendy appears to be the weakling of the pack. She needs to be protected. She needs to be helped. She needs to be coddled. She needs to be saved by Donna and the defendant. Donna is the overbearing matriarch who nags everyone to death about whatever it is that's currently on her. I call it the wheel. The wheel's turning all the time, right? And Wendy getting away from Dan Markel and moving to South Florida was number one on the wheel. It was the top priority in 2013 and in 2014. And this defendant fancied himself the savior of this family. Equal parts black sheep and mama's boy, he would often try to help Wendy at Donna's bidding. When a problem was perceived regarding Wendy's love life, aka this breaking up with Dave situation, shouldn't break up with Dave, Dave's a great guy, Donna enlists the defendant to go in and fix it, to solve the problem. When Wendy didn't know what was best for her regarding a job opportunity, Donna sent the defendant to fix it. And the evidence has shown that Dan Markel was a major problem for Wendy, and that meant he was a major problem for Donna, who in turn made Dan Markel a major problem for this defendant. Enter Catherine Magbanova, who had connections to a criminal element, and she presented an opportunity to the defendant to do what he does and solve this problem. On Halloween 2013, the defendant began the process of soliciting Catherine Magbanova to commit murder. Magbanova solicited Garcia. Garcia brought in Rivera. So if the seed of this conspiracy was planted in the spring of 2013, when Donna was looking into converting the kids to Christianity or making this $1 million offer to Dan Markel, it took root that summer when the relocation was denied and the defendant began, quote, looking into all options to solve the problem of Danny Markel, including hiring a hitman. And the conspiracy grew further still when Dan Markel filed that motion to preclude Donna from having unsupervised contact with the grandkids, the grandma motion. And as Wendy Adelson relayed to Jeffrey Lacoste just 5 days before the murder, she was never going to be able to move to South Florida unless something happened to Danny. This conspiracy spread when the defendant met someone who could actually get this thing done. Someone who was in a position of trust in his life, a person who had connections to the kind of people who, for a price, were willing to point a gun at a complete stranger and pull the trigger. And guess what wasn't a problem once Dan Markel was dead? Relocation. Within a couple days, Wendy and the kids moved to South Florida. she changed the names of Professor Markel's children from Markel to Adelson. And just like that, their father was erased. No more squabbles over kosher diets or visitation schedules. No more death matches over marital assets. No more small town pit stop on the way to nowhere, Tallahassee. No more Dan Markel. And this case may have gone unsolved if not for a few things. Number one was Mr. Geiger. Does anyone other than James Geiger watch out for their neighbors anymore? He heard a loud noise and looked into it because something wasn't right. His observation and description of that Prius was critical to this investigation. It was really the only clue that police had from the crime scene, other than the fact that this appeared to be a targeted hit rather than a robbery attempt. How would law enforcement even start to find a single light-colored Prius? This investigation may have gone nowhere if not for the tireless efforts of law enforcement to cull through all those records you've seen in evidence or heard referenced in this case, including the tower dump, phone records, SunPass records, iPlows, surveillance videos, and so much more, looking for needles in haystacks. And they found a few. One is Garcia's phone number, which was in that tower dump from Premier Jim. And when cross-referenced with all the call detail records of all the Adelson family members, there was a single hit. A call from Garcia to Harvey Adelson on July 1st, 2014. An ill-fated attempt to confront who he thought was his baby mama's new boyfriend, but who turned out to be the father of his baby mama's new boyfriend. And then tracking Garcia's cell phone to match, time-wise, a particular SunPass that went through toll plazas at the same time as the phone. That SunPass was identified as being affixed to a particular rental car, Prius, which led to this rental contract bearing the phone numbers of both Luis Rivera and Cyril Garcia. Although you're not being asked to decide the guilt of anyone on the screen other than this defendant, it's necessary for you to understand the roles that each played in order to understand how it is that Charlie Adelson fits into this conspiracy. Whatever your thoughts about whether or how much these unindicted players are involved, today's not their trial, and you're not going to be asked to decide anything other than in reference to Charlie Adelson. What is alleged is that the defendant solicited Catherine Magbanawat to commit the murder. He conspired with Catherine Magbanawat to commit the murder with her, and that the murder was accomplished with the defendant guilty as a principal because he hired and paid for this heinous work to be done.
Nice little breaking point here. Yeah. So, Cyril, what do you think so far?
It was interesting because there was a portion where she started talking about Charlie and some of the family dynamics and whatnot, but didn't specify anything in particular. And not having seen the trial, it's not clear to me where that may have come from. But my assumption in terms of how she chose to characterize it is it probably came from witnesses, maybe Wendy, that was able to encapsulate those aspects of Charlie being kind of the savior, the guy who kind of rescues the family when necessary, is probably coming from somebody that is a lot reliable witness in terms of that, right? So those are characteristics that are likely to be talked up in a positive way and are likely not going to be refuted by the defense.
Yeah. Lots of phone calls. There are tons of wiretap calls between him
and that
mom.
is all stuff that obviously is basically unimpeachable, right? When it's basically from the people themselves, right? It's a lot harder to say, oh, that didn't happen, or didn't happen in the way that you've described it. And so she was able to gloss over it rather quickly. I'm not gloss over it, but cover it rather quickly. Because she knew kind of the strength of that particular that evidence and was able to summarize it in a way that I think the jurors understood what it was. And then she did kind of, as we kind of alluded to, was going to spend a little bit of time on the murder, but as she's kind of highlighted, it really is about the conspiracy piece, which is really what ultimately this case is about: is how do you connect a conspiracy together? And again, while I'm more familiar with California law than I am with Florida law, there's no requirement under conspiracy law for each and every member of the conspiracy to know who the other co-conspirators are, right? You just have to be in agreement as to what the conspiracy, what the objectives of the conspiracy are. And so whether or not somebody, hires somebody else to do a certain aspect of it doesn't become as important as the overall fact that you have a conspiracy in the first place. And so she's done a good job of kind of laying out how the conspiracy was birthed, like where it came from, what were the agendas and the motives behind it, and how did it kind of come together. And so now she's covering, this part of it, of the murder itself. I think one of the things that she did highlight, which I think the defense would have a hard time explaining, right? When you're using a story of, oh no, he's getting threatened, all this other stuff. Why is it so coincidental that you have this one, phone call from, two people that are seemingly unconnected, right? Between Harvey and the murderer. Why would this call even exist? But for the fact that, these are known individuals to each other. So a fascinating way of kind of connecting that piece, but highlighting something that's, seemingly small, but really an important piece of evidence when you kind of look at the overall picture.
Mm-hmm. Thank you. So
Yep.
we have about 10 to 15 minutes left, I think, of her closing.
Okay.
Do you want me to speed it up even more?
No, let's just keep going.
Okay.
And we'll take probably another break, and then you
Sure.
want to break, when we're about 7 minutes in, and then
Yeah.
we'll hit it, and then we'll hit the very, very end.
Okay. I didn't know if you have to go, if you're like on a big time crunch. So
No,
Thank-
we're good on time for right now. I
Thank
can probably
you.
go an hour and a half. So
okay,
we'll-
cool.
yeah.
Okay, let's
Okay.
go.
All right, let's see what happens when we follow the Prius. So following the Prius, as we talked about, leads to the rental contract bearing the name of Luis Rivera and the phone numbers of both he and Garcia. Those two led to Catherine Magbanua. Catherine Magbanua led to this defendant. And I want to walk through exactly how we get from this light-colored Prius fleeing the scene to the defendant. Start with Luis Rivera. The defense may seek to discredit his testimony because he's a bad dude. His status as a felon and a gang member are definitely things you should consider when you're weighing his testimony in this case. But please consider that his resume as a bad guy was precisely why he was selected to do this gruesome job. Rivera's gang status made him a more attractive candidate to do this murder with Garcia. In the hot tub in March of 2014, the defendant mentions his connection to a Cuban criminal element. Jeffrey Lacoste reported this within a couple days of the murder, when he couldn't have known the ethnicity of the killer. The evidence has shown that the connection the defendant had was through Catherine Magbanua, and the criminal element was, of course, Garcia and Rivera. And we know that at the time the defendant made that statement in the hot tub, the plan to kill Dan Markel was already well in the works. That statement was made just 3 months before the killer's first trip to Tallahassee in June of 2014. The statement reveals that the defendant wasn't scared of Catherine Magbanua and her associates. To the contrary, he was boastful. He was bragging about it. He was the big man who was going to solve his little sister's problem, make his mom proud, and get away with it because he was thinking of everything. And he later would say and call JJ that nothing was done improper and suggest that no evidence could be available to tie the killers to him or his family. And he was confident enough of this to brag about it in that hot tub setting, but could never come back to him. He was untouchable. Because if push ever really came to shove, who are you going to believe? An oral surgeon or a gang member? He's banking on that. In regards to Rivera's plea deal, the actual only condition of his plea deal is to tell the truth. And what did he tell us? Catherine Magbanua hired Garcia, and Garcia hired him to do a murder. Why? To help the lady who he understood to be the dentist's sister to get her kids. Aside from fitting with the other evidence in the case, there were a few things that independently corroborated Rivera's testimony. One is that accidental discharge that he told us took place in the rented Prius. This was a fact we didn't know before and were able to confirm upon reinspection of the vehicle. He also told us about the location and timing of the money drop on the morning after the murder at his and Jessica's residence, which was able to be confirmed or corroborated initially by phone records and now also by Catherine Magbanua's testimony. And of course, the phone records confirm Rivera did come to Tallahassee, not just on the July trip, which we knew about, but also on that first June scouting trip or attempted murder trip. The communication records tell us a few other things too. That's the June trip. July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine McBanois to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine McBanois was consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. On the stand, the defendant was asked about the use of landlines and whether he believed them to be more secure. He testified that on the call he was being asked about at that time, that he was talking about switching over to a landline because he was in a place that had bad reception. If there's bad reception in South Florida at a dental office, what about all the other mentions of using a landline that we hear on the wire? Surely he wasn't in a place with bad reception for all those calls. And why call the parents on the landline? Surely they have reception in their South Beach high-rise. In the 2 years of phone records that were examined in this case, the defendant talks to his parents on the landline 28 times, or 0.07% of the times that he talks to them. So mostly on the cell phone by a large majority. 3 of these 28 times were on the days that the cars were rented to do these trips to Tallahassee. Whether or not that is a coincidence is entirely up to you. After the killers returned from Tallahassee on that first trip, we have a couple text messages of interest. On June 8th, 2014, the defendant indicates he's still working on Dad's birthday present, and Donna indicates, I know you'll come through. Then on July 6th, we've got Wendy Adelson with a location at or near her parents' place when she texts Dan Markel and confirms he's going to be in town for his own murder. This slide depicts the night before the second trip. We know Catherine McBanois and the defendant are together that evening at her place. He departs between 12:42 and 1 a.m. And then after the defendant departs Catherine McBanois' residence, we've got Catherine McBanois calling Sigfredo Garcia. So within minutes of the defendant leaving, she calls Garcia. She talks to Garcia several more times into the wee hours of that night, the last one being at 1:56 a.m. And then at 9 a.m. the next morning, Garcia calls the rental car place. Once the Prius is rented, the second trip begins. The Prius is rented at 6:15 p.m. on July 15th, 2014. There are several calls between our parties on the day that the Prius is rented. So we just talked about the night before the Prius was rented. On the day the Prius was rented, we've got these 2 calls, several calls, including these 2 calls from the defendant to his parents' landline. Garcia and Rivera then depart for Tallahassee July 16th, about 2 p.m., and arrive in Tallahassee around 1 a.m. Although this trip was only about 36 hours from the time they left Miami to the time they returned, there were 12 phone events between the defendant and Catherine McBanois during that time, and there were 4 phone events between the defendant and Donna Adelson during that time frame, including late into the night on the night before the murder. On July 17th, McBanois relayed to the shooters that this murder had to be done that day because the victim was scheduled to leave town the next day. And we confirmed that Dan Markel was in fact scheduled to leave for New York City the next morning on July 19th. It's hard to imagine how Luis Rivera could have obtained this information, if not in that pattern that we consistently observe in this case. Defendant to McBanois, to Garcia, to Rivera, and back the other way. Certainly you're not really to believe that the killers divined this information from the professor's log. That's not reasonable. Wendy offered that Danny sometimes put his travel information on Facebook, but you learned from Agent Sanford that there was no information about this particular trip on Danny's Facebook, so they didn't get it from there. This is because, as Rivera and McBanois both told you, this information came in the form of that letter from defendant through Catherine McBanois. How would these 2 hitmen even know where to go or who to kill if they hadn't been given any kind of instruction? Catherine McBanois said she knew the plan was to kill Wendy's ex, but she never knew his full name until after he was killed. She did, however, deliver that envelope that the defendant put in her diaper bag to Sigfredo Garcia. The paper she knew contained the instructions for the murder. Defendant advised Catherine McBanois that she should not touch the envelope or open it, as he had taken precaution to ensure that his prints and DNA would not be on it, that it would be untraceable to him, and she should do the same. She was to deliver the envelope to Garcia, and that's what she did. This is corroborated by Rivera, who says Garcia had a paper with him on the first trip, and it contained a picture of Dan Markel and a printed address. The day of the murder, we have communications between our parties as listed here, with the red line representing the time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine Ibano, to Garcia, and back. We have Wendy getting a text message on the day of the murder about her TV repair appointment from her mother, Donna Adelson. It indicates that Best Buy is on their way over to help you with the TV sets in your living room. Maybe she didn't remember which TV was broken. At 8:20, on the day of the murder, Wendy texts the defendant, "This is so sweet." That text was deleted. What does it mean? At 9:19 a.m., because it's cheaper than hiring a hitman. Only you guys can assess if you think that might just be a coincidence and nothing more. The Prius is at premiere at 9:16 a.m. The last phone communication between Garcia and Rivera is at 9:16. Afterwards, the phones turn off, consistent with what Rivera told you. We turned our phones off because we knew we were about to commit the murder, and they don't pop back up until, I think, about 12:30. The bus video catches them turning onto Benton Road to do the murder at 10:51 a.m., whereby they pull up right behind Professor Markel in his driveway. Segredo Garcia gets out of the Prius, approaches the driver's window, pointed his gun, and fired. Dan Markel raised his arm to protect himself, but it was no use. Professor Markel was executed at close range, whereby Garcia got back in the Prius and Rivera drove them away. Markel was left there to suffer and die. If not for James Geiger, there's no telling how many hours he might have suffered there alone and unaided. He fought for his life for 14 long hours before he finally succumbed to his injuries. The autopsy confirmed that he was shot twice at close range with a .38 caliber revolver, consistent with what Rivera said they brought as the murder weapon. Next, he was stripped, x-rayed, photographed, and dissected, because he had become a piece of evidence. When Garcia and Rivera get back on the road, they're on a second bus video, leaving town at 10:55. That narrows the time of this shooting down to a 4-minute window between 10:51 when they're seen turning on to Benton and 10:55 when they're caught fleeing the scene. And then we've got the 911 call from Mr. Geiger at 11:01 a.m. The first phone call that either Garcia or Rivera make after turning off their phones to do the murder. So first call after that is at 12:30, and it's Garcia to Catherine Magbanua. Magbanua assures them that they'll get their money the next day. This is the same time frame, roughly, that Wendy Adelson was visiting the crime scene. Wendy indicated that she went to turn onto Trescott from Centerville Road, observed a roadblock, and then turned around. But we learned that what she said happened could not have happened. Instead, the roadblock was all the way down here by the blue dot, I've got two blue dots. The one at the top left of the page there is where the roadblock was, that yellow line, 3 to 5 houses down from the scene. Trescott and Centerville is all the way down where the other yellow bar is. Visible from the roadblock that she approached and was observed doing so by Officer Brandon were multiple law enforcement vehicles, marked vehicles. There was crime scene tape up. There was a marked vehicle with an officer stationed at the perimeter. It was visible from that position that there was something going on at her kid's house, the house where they lived with their father. And what did Wendy Adelson do upon encountering this roadblock and observing that the police were present on the street where her kids lived? She turned around and proceeded to the liquor store to pick up her bullet bourbon. And the defendant says, well, this is another coincidence because she was asked to bring it to a party. Well, maybe. But the timing of the purchase and the fact that she went out of her way to go by the crime scene on her way to get the bullet bourbon should raise an eyebrow. But it's what she didn't do that's even more suspicious. She didn't ask Officer Brandon, hey, what's going on? She didn't call Danny. She didn't call the police to make any inquiries, or even the daycare to make sure her kids made it there that morning. Remember, Danny had her kids. She didn't even call the daycare. Meanwhile, our shooters are headed back to Miami. They pop up on an ATM camera at 6:45 p.m. in Pembroke Pines, Florida. And then both of their phones are consistent with being at Rivera's residence as of about 7 p.m. that night. At 8:23 p.m., Catherine Ivanova and the defendant make plans to meet up at his house. At 9 p.m., Donna texts the defendant, "Outside your house," to which he responds, "10 men." He told you from the witness stand that this text meant that Donna was just passing by his house on her way to Tallahassee and that they weren't meeting up. But Catherine Ivanova testified that when she arrived at the defendant's house, the defendant advised her that his parents had just been there, and then he thought his mom had physically washed the money, which was damp when Catherine Ivanova received it. Ivanova finds the defendant to be carrying his gun around and in a frantic state. About the time that these two are meeting up at the defendant's house to do the money exchange, Dan Markel is pronounced dead at TMH. So he says he's going to be about 10 minutes out. Here he is hitting at home at 9:40 p.m. At 9:46.
Okay, that was a long stretch. I think it's going to be over soon. So, okay, what are your thoughts?
It's interesting how she's tied up a lot of, well, because of the fact that she marched through everything. What you're seeing is the conspiracy from a lot of different perspectives, right? And it's also negating any of the defense's possible argument that he was extorted after the murder happened, right? Because there's information bouncing back and forth that would only be flowing in one direction. And it wouldn't be possible to have it kind of going the other way. In her comment about, how would these two individuals have known where Dan lived, but for the information that was coming to them. So she's done a very good job of laying out all the different pieces of the puzzle and really tying in even Donna and Wendy very much into, what's taken place. And she's asked them, very rhetorical questions to the jury of, what do you think about this? And that's a powerful way of doing it without necessarily saying, hey, this connects these individuals. She's doing it in a way that basically, hey, jurors, you guys can see this as obvious as I can, right? Like, this is pretty obvious. So I think it's been an effective way of tying her case together. I can see where she's going to wrap this up. But yeah, it's been a very effective presentation. And she has touched upon all of the key elements that you'd want to talk about. When it comes to Rivera, why would he testify the way he has? And little tiny bits of information that help corroborate his story that wouldn't otherwise be known, right? And that helps kind of reinforce that idea of like, this is the most reasonable story because it ties in all of these things. And then when you contrast it versus the defense, because I provided this level of detail as a prosecutor, right? How are you going to try to weave a different story and tie in all these facts, right? Because it wouldn't fit with their version of events. And therefore, this is the only reasonable interpretation as to what actually took place. So very effective way of kind of bringing it all together and really kind of hammering it in where you need to. Because obviously, from the Adelson's side, as you're getting closer and closer, you're not going to want to leave a lot of a trail, but essentially they have. There's not a lot of text communication, but phone calls are the way they've gone. But those are also helping to establish, hey, these are conversations that are happening. They're not small conversations. They're lengthy conversations. And when are they in relation to other conversations? When are they in relation to things that we know that are happening? How are these text messages falling in place, when these events are happening? But I think that last bit in terms of Wendy's conduct, to really, and she doesn't need to prove that Wendy knew, but the very obvious points of here's a mother who sees something and yet does the complete opposite of what any other mother would do in those circumstances if they did not know something had happened. You'd be deeply concerned. Oh no, wait, could that be something that is in the neighborhood of my ex-husband's residence, right? You would make that phone call to see if Danny and the boys are fine. Even just to ask, hey, is everything okay? I see police activity, whatever, is everybody okay? Right?
Mhm.
And she doesn't do that. A very obvious thing. And kind of those things that she kind of hammered away at. So really kind of highlighting the fact that the family knew something had happened. And the only way that makes any sense is if they were behind it. So a very effective way of kind of bringing that home.
Mm-hmm. Okay, thank you. Okay, let's try to finish this.
6, we see Catherine Magdanois consistent with being at Rivera's residence, and then consistent with heading toward the defendant's residence. She turns her phone off, and it stays off for 11 hours. When Magdanois's phone pops back up, it's 9:44 a.m. on Saturday morning, and she's headed back from the defendant's house, or the direction of his house, toward Rivera's residence. That's the money drop location. These phones are consistent with a meeting at 10:30 at Rivera's, which is the time, date, and place that he advised us he received his money from Magdanois. At 12:13 p.m., the defendant reaches out to Magdanois. Defendant, headed to the gym. Are you taking the kids to the beach? It's so nice. Magdanois, it's beautiful, probably the pool. Defendant, nice, have fun. Ethan must be happy. This is what he's texting Magdanois within hours of her leaving with all the money in his safe. All of the money that he stared at and loved on since he was a child. And he wants to know if she's going to the pool. This might be a good time to remind you that the jury room is not a place to check your common sense. We want you to bring it in there. You have heard 2 wildly different versions of how this thing went down, and they can't both be right. I mean, somebody's trying to sell you a bill of goods. You were selected with the belief that you would be able to cut through the garbage and make sense of the evidence in this case and render a verdict that speaks the truth. A major problem for the defense theory is the idea that the defendant and Magdanois broke up after the murder, but then grew closer together over the next 2 years as she was collecting his monthly extortion payments. This is one of the more unreasonable parts of the defendant's testimony, or was definitely in the top 4, along with Latin King extortion payment plans, hitmen that hire themselves to kill someone that their intended future extortion victim hates, and most unreasonable of all is probably that Charlie Adelson, the guy that talks so tough in a hot tub about his unsavory connections, but an arrogant man of extraordinary resources, a prize fighter of verbosity, would just lay down and take this in silence. Let's review some of these love checks. We've got that one. Then we've got July 22nd. They're talking about the weather. They're talking about prescription shampoo. On October 6th, the defendant says, I love you. It makes me feel good that you care about me. I'm very lucky to have you as a part of my life. What? Lucky? Lucky. He says, I love you again on 2/24/15. According to him, he's now been making payments for 7 months. He's had her on the payroll for 6 months. No Latin Kings have contacted him in any way about collecting his outstanding debt of $195,000. Yet he continues to pay and love on Catherine Magdanois without reservation and without the slightest suspicion that she might be in on this, and without the slightest concern for helping solve the murder of who killed his brother-in-law. Defendant says he believed Catherine Magdanois wasn't taking any of the money even after he put her on the payroll. Checks are going to her because she seemed broke. Defendant's explanation for all the love texts with Catherine Magdanois is that he felt sorry for her. He felt she was in the same position that he was in, being manipulated in the same way that he was. But the fact remains, folks, that she's taking his money. She's connected to the guy that's extorting him. She's connected to the guy that killed his brother-in-law. It defies logic that he would then proceed to grow closer with her. But he has to say that because he can't, there's no other way around these texts. It also defies reason based on what we know of this man, that he would take her for her word and just empty his safe into her purse and then keep paying, presumably forever, without asking any questions, talking about it all, or reporting anything to the police. Magdalena began getting checks from Adelson Institute 2 months after Markel's murder, and she continued receiving checks from that time frame up until the bump. The checks stopped happening at the time of the bump, and you should be asking yourself what that means. Why did the checks stop happening? Well, you would reasonably figure they stopped happening because the parties got spooked, because law enforcement, they suspected the bump could be law enforcement might be getting closer, take her off the payroll. If defendant was being extorted, as he told you on the witness stand, why would the payment stop? Why would the extortionist care if other extortionists had jumped on the bandwagon? Why would the bump impact the defendant's existing obligations to the original Latin Kings? The defendant said he put her on the payroll at Adelson Institute at her request to help her get insurance for her kids, with the understanding that the money was being funneled through her to someone else and she wasn't actually getting any of the proceeds. She was just going to use that paycheck to assist her with getting subsidized housing or insurance, I think it was, for her kids. But you can see from this slide, which is dated June 24th, 2014, that she's texting him about getting on the payroll prior to this alleged first extortion effort. He says no problem at that time. This is between the first and second trips. She's asking to be on the payroll. So the explanation from defendant about why she's on the payroll does not fit with the other evidence in this case. So we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators. And each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I've talked about. It goes from this one to this one to this one. But as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key events are just a coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can be shaped like a wheel with one central hub talking to all the different spokes. Or it can be shaped like a train car, which is what we have here, where one person talks to only the car in front of them and the car behind them. Law enforcement was asking these same questions. How is this conspiracy shaped? How does it work? How does information flow through it? What are different parties' relative roles within a conspiracy? And the wiretap and bump were designed to answer those questions. Did you notice that Donna Adelson, see how the paper is folded in half? She didn't even look at the paper before she put it in her purse. She didn't think this was a process server. She knew exactly what it was the moment this man approached. And then she just goes about her business. Does she give law enforcement this valuable information that could be used to solve the brutal murder of her son-in-law? I mean, this guy that approached her obviously knows something about who killed Dan Markel, right? So surely she went straight to the cops. Nope. Instead, she goes straight to this defendant, who goes straight to Catherine Alabama, who goes straight to Cyril Garcia. In that first call after the bump, Donna says she doesn't want to talk on the phone, but defendant can't leave it alone. He asks, does it involve me or other people? Her answer, well, probably the both of us. Probably both of us. He says, what's that? Probably the two of us. So you probably have a general idea what I'm talking about. He doesn't say, no, I have no general idea what you're talking about. He says, all right. He absolutely does have a general idea what she's talking about. And if they were innocent, as the defendant has claimed, and this was in fact a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. In call B, the defendant asked Donna to take a picture of the bump letter and send it to him, and she refuses. Why? Are the Latin Kings going to see the text? Do you think someone is trying to blackmail you? Maybe. Could be. I don't know. No. That's crazy. That's his response. I'm not adding the emphasis on that syllable. He says it like that. That's crazy. How is it crazy? You're already being extorted by Lion King members. Remember, doctor? Says he hadn't come up with that part yet. In call C, defendant calls back again to tell Donna not to talk about things in the apartment or any place. Why? Why? The Latin Kings aren't in there. And she doesn't ask why, because it's obvious. She says, oh, obviously. Why? Because they might be under surveillance? Well, who cares if they have nothing to hide? Here we see the first use of code on the wire. People don't talk in code if they've done nothing wrong. People do not talk in code if they haven't done anything wrong. Defendant knows, he knows that fact, and that's why he told you we didn't talk in code on the wire. We spoke carefully. What does that mean? Careful of what? Defendant also told you under oath that he regrets that his mom randomly used the word TV in this call as part of her careful talk. The defendant got Wendy Adelson a TV as a divorce present as a cheaper alternative to hiring a hitman. Dan Markel was killed by a hitman. Then the same TV is Wendy's alibi for the murder, a service appointment that her mother set up for her from South Florida. And then on the wire, Donna says, quote, this TV is going to cost about $5. Does the defendant say, what TV? What are you talking about, since you inserted a random object into this careful talk conversation? No, he doesn't need to ask what TV, because he knows exactly what she's talking about, and he parrots it back. They asked you for $5,000? The defendant has advised you that this TV stuff is a coincidence. Is it a coincidence, or is it obvious they're referring to their conspiracy in this murder? Only you can decide which explanation is credible. The players in this case are smart. They've given a lot of thought to their preparations before this and to their explanations after. We know the seed was planted in early 2013, and it took over 1 year to come to fruition. And they've really thought of almost everything. A clever TV-related alibi for Wendy, a frame job for Lacoste, and they insulated themselves by hiring Catherine McDaniel as a middleman, walling themselves off like those train cars, only communicating with the one in front and the one behind, and having no connection to the one further down the line. It's also important to note that in these first few calls, A, B, and C, that Donna Adelson describes the bump to the defendant, and she says the person that approached her mentioned an ex-girlfriend, but she does not say the name Katie or Catherine. Then, with only this very limited information, defendant calls only one of his many ex-girlfriends, Catherine McDaniel. In call D, defendant tells McDaniel that he thinks that this undercover, the would-be extortionist, said her name. We know this is true. The undercover did say Katie, but Donna had not yet told the defendant that. They only communicated in calls A, B, and C. And the only communication on those calls was that the person mentioned ex-girlfriend. On the wire, the defendant says he just called Katie, Catherine McDaniel, because she was his most recent ex-girlfriend. Well, we know that's not true, because there's at least one woman that defendant will admit meets that definition between McDaniel and the bump, and that's Whitney Kick. On the stand, he told you all that you might not be the right Katie conversation. There's several mentions that, yo, I'm not sure you're the right Katie. I apologize. I'll feel stupid if you're not the right Katie. That was designed to reassure her that he was not setting her up. Once defendant meets with his mother and gets the details and the paper with the undercover's phone number, he meets up with Catherine McDaniel at Dolce Vita. If they had any evidence, we'd have already gone to the airport. Does that sound like an innocent man? Even if they bug your phone, you're still not talking about any of this. Talking about what? The cops would only bug your phone to get information about the murder. And if you don't have any, then there's nothing to not talk about. The cops aren't going to be doing a wiretap to investigate him getting extorted, which he hasn't even reported to law enforcement. So, not talk about what? Defendant discusses how he's going to start arming himself and is prepared to shoot. He told you under oath from the stand that he was being threatened and extorted by gang members for 2 years at the time that this recording was made. And now he's just starting to think about carrying a gun? Does this sound like a man that's been living in fear for 2 years? Does this sound like a guy who lays down and takes his lumps without question when threatened? Someone comes up to me asking for money in my house? He says that. Lines 23 and 24 on the top there.
Okay. Sorry, this is actually lasting longer than I had anticipated. I thought it would be over soon. So any quick comments here?
No, I mean, she's getting into the back half of like post-murder, what's the conduct, and again, really kind of poking holes in the story that the defense has laid out. So, you know, it's getting protracted, but it's very detailed. And so I think she's driving home her point. It's just something that she needs to kind of go over to some amount of detail to be able to kind of point out where the weaknesses of the defense's argument are. So yeah, that's pretty much it. I mean, just kind of recapping what she's doing, but it's you know, it's an effective way of going about doing it, because you do need to address what the defense's story is, you know, through its entirety. And, you know, obviously she weaved in the cross-examination of Charlie into this portion of it to explain where it is that where his story makes, you know, no sense at all. Because obviously the defense's story comes from Charlie. And when you're able to point at these very obvious things that are inconsistent with that story, that you're being extorted, and play that up, it really helps the jury kind of, you know, take down his story. And once you've done that, and because the defense entirely rests on his story, then the entire thing crumbles. So,
Have you noticed the demeanor of Charlie Adelson in the background, as well as his attorney?
I have, to some degree. I mean, there's not much you can do in those instances, and obviously the camera happens to be pointing in that particular direction, and so you kind of see some of what's happening. There's really not a good or a bad way of responding. There's not much you can do. As a defense attorney, you can, for example, you know, smile, laugh, giggle, just kind of show from your body posture that you don't believe a certain aspect of the prosecutor's argument. But you don't want to react too strongly to anything that the prosecutor necessarily is saying. But it kind of depends on how you go about doing it. You know, Charlie, like a lot of defendants, he's not moving around a ton. He's been pretty quiet in his movements, whereas his attorney has been a little more obvious. But yeah, that really doesn't belie anything, and it's not uncommon for different defense attorneys to act differently during closing arguments by the other side. So,
yeah. Have you ever seen a judge admonish someone for, you know, maybe shaking their head too much or making faces or something?
I have not. That's not typically something that a judge is going to highlight unless it's disrupting the prosecutor's argument. You know, and or if it's distracting to the jurors, right? And so typically I don't see that. If a defense attorney wants to do something, they would object during a closing argument. And then that would break the rhythm of the prosecutor. You'd probably have a sidebar to explain why exactly there's an objection being laid. If there's something that's, you know, the DA is saying that's inappropriate, that type of a thing. But that's where if you want to actually have a disruption will take place, is to do that. But yeah, there's nothing that he's doing that I would imagine would draw any ire of any judge. There's nothing you know, demonstrative or inappropriate under this context.
Okay. Do you still want to keep watching this? Or
I don't know how much is left of it.
Okay. Let's see.
We can go a little bit further if you. Yeah.
Let's see. Oh, geez. Okay. So there's Charlie looking bummed out. Okay. So I think there's probably, oops.
Yeah.
There's more like 36 minutes. So even if we speed it up, that's still another, you know.
Yeah, no, I don't think we're going to be able to finish that today.
Yeah. Okay. Okay. Well, do you want to just watch for a couple more minutes?
Would you want to tackle any of the questions that you have? I don't obviously know if there's anything in there.
Okay. Well, actually, I don't see any questions. So if you guys have questions for Cyril, please put it in the chat with a question mark first. Okay.
Do you want to do another 5 minutes and then just wrap this up, because I'm kind of running out of time on my end?
Okay. Sure. Okay.
He says this as if it's a preposterous proposition that somebody would just walk into his house and demand money. Isn't that what happened to you? How is that preposterous? But wait, what changed? On the next page, he says, yeah, and guess what? When the fucking police show up and there's a doctor, there's an oral surgeon standing there with a dead gang member in his fucking driveway, they're not gonna come down too hard on me. This is the same man who took the witness stand and swore under oath that he was a victim in this case, and that he had been too paralyzed by fear of gang members to come forward and report his victimization. Dr. Adelson on this recording is the real Dr. Adelson. On the stand, he was so controlled, so knowledgeable about his case, so practiced. But there is no way to explain away his statements on this recording. When the bump happens, you get to observe this defendant in action in his role as fixer, a problem solver. He's working those phones, trying to get Katie to investigate the bump and find out if it's legitimate or not, and also trying to reassure Donna that it's just the cops fishing and it's nothing to worry about. The bump is an actual recorded example of how this defendant acts when he is threatened by a purported extortionist. And how he acts is the complete opposite of how he's telling y'all he acted in the first extortion. Number one, he does not stay quiet about the bump. He talks about it a lot. There are multiple calls with Donna and Katie discussing the bump and what the next steps should be. Two, he takes action. There are multiple in-person meetings with his mom and with Katie and eventually with his dad too about the bump and what to do about it. Three, he investigates the bump. He asks questions. He enlists Magbanua to find out who this is. He talks a lot about his concerns that this will not be just a one-time payment, but could turn into some ongoing problem. And four, he doesn't take it lying down. He threatens Nazi shit if these people think they can threaten his family and get away with it. He suggests that the problem might require an additional murder. Quote, if he can't do it, I'll find someone else that can. Number five, he's suspicious. He does not blindly accept the representations of this purported blackmailer that approached his mother. It's clear from the Dolce meeting that he doesn't fully trust Katie. He certainly doesn't trust this purported blackmailer that bumped into his mom. The person that represented themselves, the person that approached his mom represented himself as a Latin King gang member, right? I'm a brother of this guy that I met in Broward or whatever. And he's demanding money from her. Yet the defendant does not take his word for it that he's a gang member. He's not so in fear for his mother's life that he opens the safe and gets $5 grand more out and gives it to Katie. A pittance compared to the amount he's telling you he handed out to the first layer of extortion. Number six, he doesn't pay. He doesn't bring the $5 grand to Dolce and give it to Katie and say, go pay it. Because that's what I do when I threaten to pay. He doesn't pay, he doesn't ever pay. And it's only $5 grand. Instead, he analyzes and thinks through and talks about every possible scenario. Defendant says it's one.
Okay, due to time constraints. Yeah, sorry, I didn't realize this was so long because I saw some other video of closing and it had appeared to be 55 minutes. So we do have a couple of questions. Do you have time to take it?
Yeah, let's go.
Okay, so thank you, SP. Big question is, why haven't they arrested Wendy yet? If they don't need her testimony with her type of immunity, would she avoid being charged if she cops to everything in Donna's trial? Not sure if you can answer this.
You know, I can't really answer that. I think I've talked about it in on a prior appearance. The DA isn't under any type of time constraint as it relates to arresting Wendy, and just because of how methodically they've gone about this, I don't suspect that this would be a scenario where they would do that. Obviously, Donna's next up, and you can kind of see that. As they've gone about prosecuting, right? They started off with the killer, and then they extended it out to Katie, and then they extended it out to Charlie. So I think they're very deliberate in how they're going about doing it. This is a very particular plan, and they're rolling out the evidence when they need to, and it kind of makes sense how they're going about doing it. If they still needed Wendy's testimony, because it still is the foundational piece in terms of laying out what exactly is the motive. All of the things relating to the divorce. You're certainly going to see a lot of that come out during the trial and prosecution of Donna, because obviously that's a critical aspect of it, is her communication with the other members of the family. And with her type of immunity, I think, if I recall correctly, in terms of looking at it, and it is set up differently in Florida than in California, they're able to serve a subpoena on her in a manner that allows her to testify with immunity, that those statements can't be used against her in her subsequent trial. But I don't know that that's going to be a problem, because they do have essentially all of the documents from the divorce proceedings, and there's other witnesses that talk about her demeanor as it is. So there shouldn't be a problem with that. And I don't imagine that Wendy's going to say anything different during Donna's trial. And would she be able to avoid charges if she copped to stuff? That would largely depend on if she feels like she's in a position where she needs to talk to the prosecution to try and cop a deal. Obviously that's entirely between her and any attorney that's representing her to make that assessment based on the evidence that they've seen thus far, and also from the prosecutor standpoint, like, do they really need her at this point to do that? Would the trade-off be worthwhile? Do they think that it's so hard to get Wendy that it would be better to have her testify against Donna? Maybe that might be true, but there's a lot of unknowns at this point in terms of how the DA sees the case. Certainly in the closing argument that we've been kind of reviewing, this is more evidence that we've seen that wasn't, by my recollection, necessarily covered in the trials that came before. So you're starting to see a lot more reliance on statements, text messages, wiretap stuff, because it's far more relevant to this trial against Charlie, and it's going to be far more relevant to the trial against Donna. There may be things that they haven't chosen to use because it may not be as relevant, but may be more important as to that. But I don't know that that the prosecutor is in a position where they would be like, hey, we can't get Wendy, so we might as well try and flip Wendy. I don't know that they're at that particular point, but
okay,
kind of the problem, not knowing what the case is, right? In terms of the evidence.
Yes. How much of the previous trial info will be allowed into Donna's trial?
They're going to have to basically present all of that same evidence yet again, and all of it, because of the fact that it's a conspiracy, all of it is going to be admissible. So they're going to have to basically put the whole trial on and add more if they've got more against Donna that they want to specifically introduce. But I would expect that you're going to see everything that was put on during Charlie's trial, plus anything else if they choose to add it.
Okay, thank you. Would it have made a difference if Charlie hadn't taken the stand?
Not having seen the trial, I think it's hard for me to answer that question. What I would say is that if you take away Charlie's testimony, then you take away what the defense is that they've laid out, right? And then you're just simply saying, hey, there's not enough proof that ties us all together. And that's a strategic decision that oftentimes the defense has to make. Is it easier for us to attack the people's case and try to poke holes in it and then tell the jury, I don't think you've proven it beyond a reasonable doubt? Or is it more beneficial to put on an alternative story that presents a through line that is just as reasonable? Because if you have two reasonable explanations for something and one points innocence, and you're required legally to vote for not guilty. So it's hard to say in this particular context how that would have approached. Just based on what I've heard thus far in closing argument, I would say that the case is pretty strong. And so if they were just simply taking an tact of trying to poke holes in the prosecution's case, they might run into a lot of problems. But certainly this last portion of the argument wouldn't be happening at all in the manner that it is had he not presented that particular defense, right? There would have to be something in their cross-examination of the witnesses that where they would have to present some type of alternative explanation, but they wouldn't necessarily have to have that through line of, oh, this is a second extortion, or there's more extortion that's happening, that type of thing, because it does obviously become much more problematic to justify this when, as the prosecutor's going through and saying, well, if you're being extorted all the way through, why did your behavior change when you think you might be being extorted again? So you wouldn't have that same argument if you hadn't taken the witness stand, but I don't know that would have made that big of a difference in the ultimate outcome.
Mm-hmm. Okay. Another question?
Okay.
Okay, let me know. Okay. Prosecutor is closing in state court. Is there a difference between a closing in state versus federal court? Could a prosecutor give that closing in federal court?
I've never practiced in federal court. My experience has only been in state. So I really couldn't say what the rules are in regards to a closing argument that's in federal court. So sorry, I really can't answer the question, unfortunately.
Okay. Yeah, not sure. What do you think about Wendy lying on the stand? Does use of derivative immunity still apply if Wendy lies on the stand?
Again, based on how Wendy's lying on the witness stand ultimately helps the prosecution when you look at it from that standpoint, because there isn't an expectation that she's going to be truthful, and nor are you treating her necessarily as a truthful witness, right? You're trying to get very specific information out of her for the purpose of your presentation of your case, and so you're going to expect that to some degree she's going to minimize her conduct, she's going to downplay certain things. Paint herself more in a positive light, even when the evidence is to the contrary. And so as it relates to the immunity aspects of it, so in the manner that she's testifying under Florida law, none of what she's is basically saying could be used against her. Could you separately attack her for just perjury and charge her with that? Sure, you could, but that's ultimately not the goal here. The goal is basically to secure a murder conviction against Wendy down the road, if that's the direction that the state chooses to go. And so that's pretty small potatoes in the grand scheme of things, and not really worthy of wasting the time to do that. So yeah, the immunity aspects of it, there really isn't any difference between whether or not she lies or tells the truth on the witness stand. The immunity is the immunity. The reason why you're giving immunity is because the expectation is that someone is going to say something that is potentially damaging to themselves and in violation of the Fifth Amendment rights, right? So that's why that immunity exists in the manner that it does.
Okay. Maybe one last question.
Sure.
I can't seem to be able to flash it on the screen, but this is a general question, like how do prosecutors get assigned their cases?
That really varies from prosecutor office to prosecutor office. Some offices handle them very differently. They kind of a cradle to the grave type of approach. So you handle the prosecution from the very start of your case to the very, very end. In other situations, you use a different type of model where multiple prosecutors can be touching a case. And at the end, there's one prosecutor that handles the trial or resolution of that particular case. In terms of how cases are assigned, again, that also depends on how your prosecutor's office is set up. When you have a smaller office, there's a greater likelihood that you're going to handle a wider variety of cases, and where you're really differentiating is between experienced versus non-experienced prosecutors. And so you'll have, the younger prosecutors, props handling misdemeanors, but they're going to move up pretty quickly to low-level felonies, to much more serious cases. The larger the office you have, the more segmentation you can have. So my office, for example, we have, very specific units that handle homicide cases, gang cases, sexual assault cases, domestic violence cases where we call under the family protection umbrella. We have two different insurance related units dealing with fraud. One's an insurance fraud, another one's a major fraud. unit. So the larger the office you have, the more specialization that you can have, and you'll move prosecutors around, that type of stuff. So yeah, and then that in terms of the cases, then you're getting them because of your particular assignment. So.
Okay, great. All right. Well, let's see. Okay, just really one last one. Okay, Wendy wants to take a trip outside the USA because this is how Donna was arrested. She was trying to get on a plane to go to Vietnam. Do you think she would be arrested at the airport like Donna?
Again, that's something that only the prosecution is going to know what they're prepared to do at what point. One of the things that as prosecutors that we're generally concerned about is where are the individuals traveling to. We have extradition treaties with different countries around the world, but they're not all the same. And so sometimes we're going to be more successful getting back somebody from a particular country than from another country. And so that may come into play, but honestly, it's hard for me to really kind of extrapolate, what might happen in that particular instance. It largely depends on what the prosecution thinks, where they're at, and kind of, it may very well be a situation where, her choice to do that may force the prosecution's hand, where they decide, all right, we're going to have to arrest her at this stage. Take your passport and all the rest of it. Once you've initiated criminal proceedings, you can certainly tie down certain conditions in terms of, is she allowed to have her passport, that type of stuff, to eliminate the ability for her to flee. It doesn't take very long to put together an arrest warrant, but the prosecution's got to make a choice. What do you want to do with her at this particular point in time? So.
Okay, great. Okay, thank you so much for your time. Sorry, we're totally gone overboard with all the taking up your time and stuff, but I do
not
appreciate
a problem. It's a pleasure to hang out with you and to talk about this case. So thanks for inviting me again. This was a lot of fun.
Cool. Okay, you can hang on a second if you want to, but we'll go ahead and say goodbye. Thanks, everybody. Thanks to the mods also. So take care.